Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. For today's live coverage, we have two stories for you. We're going to be talking about coverage of Sarah Palin's lawsuit against the New York Times for defamation, which has come to an end, but through some fairly questionable methods. And we're also going to rage a little bit at TikTok's new policies when it comes to, inclusivity, which may not include certain things, which you know what those things are without me even telling you, but we'll rage it in any way. All right, so let's start off with Sarah Palin. Now, this story is interesting twofold. Of course, it's obviously interesting in so much as it relates to Sarah Palin, but it obviously speaks to some broader issues that are facing the judiciary in these increasingly interconnected times with mobile communications and so forth. So let's read a little bit about the issue and discuss the broader implications. Jurors in the Sarah Palin trial said they knew of the judge's decision to dismiss before they reached their verdict. The judge said several jurors acknowledged knowing about his decision, but said it had not played any role whatsoever in their deliberations. Okay. So we've discussed a lot of these issues kind of before, right? We discussed it in the Kyle Rittenhouse trial when we kind of are all kind of hoping for this at some points. And we can talk about it in other kinds of contexts. This obviously is a civil case rather than a criminal case, which raises slightly different concerns, but still, for the same reasons, a judge can interfere as part of the process, basically by saying there's no case, for a whole bunch of reasons, and they probably should at certain cases when there's no evidence to something, right? So one of the judges act a lot of different ways on this. Some judges dismiss fairly early. Some judges allow things to go fairly late into the day. And some judges are more willing or less willing to intervene in the process at any step along the way. So it's not particularly surprising that a judge would want to necessarily make a ruling that would decide a critical legal issue while the jury is deliberating. It is a little bit weird that they let the jury keep deliberating, although it does make some logical sense. Because if the jury goes the other way, and then he reverses them, basically, effectively, by entering the dismissal, then you know what the jury would have done. So there makes some sense, right, to allow the possibility for appeal based on what the jury would have done. So if the judge is incorrect on the legal finding, then you have the jury's verdict in place, so you don't have to speculate. So that is probably what's going on here in terms of the motivation. But what happened is the jury learned about his decision while they're still undergoing the deliberative process. And they say, the jury say, it doesn't play any role whatsoever in their deliberations, which is kind of hard to believe. But that's apparently what they're saying. Let's discuss a little bit more about the issue. Several jurors in the defamation case brought by Sarah Palin against the New York Times say they found out about the judge's decision to dismiss the case while they were still deliberating. The judge said in an order. So the judge knows this, and the judge has put this on the record, which makes that now an appealable issue. On Monday, while jurors were still deliberating, the judge said he planned to dismiss the case if the jury found in Ms. Palin's favor. The next day, the jury delivered a verdict also rejecting Ms. Palin's claims, but they might have been influenced by the judge. The claims were based on a Times article in 2017, an editorial that erroneously had linked her political rhetoric to mass shooting. Now, Sarah Palin is pretty much the quintessential definition of a public figure. So you can get away with a lot. So it isn't particularly hard to imagine why this case would fail just on sort of like superficial details, right? Without knowing a little bit more about specifically what's going on, which might change the analysis quite substantially. But, merely, suggesting someone's rhetoric is leading to something or creating a tie to it may not be enough, particularly when you're as public a figure as Sarah Palin is. Pretty hard to be much more of a public figure. The only one who can be probably more public is probably the sitting president or sitting vice president. It's about the limits of that. So, in an order Wednesday, the judge said the court's law clerk had spoken with the jury after the trial as part of routine inquiries and was told by several jurors that they have found out about the ruling through push notifications from news websites onto their smartphones. And here we get onto the broader issues that face courts as we deal with technology, because people have cell phones and they're instructed not to look at the media. But if they look at their cell phone and they get a push notification that says something about their own case, this is a bit of a problem. And how do we correct for this problem? I don't know, but I'm just asking questions at this point. The jurors repeatedly assured the court's law clerk that these notifications did not affect them in any way or played any role whatsoever in their deliberations. But now here's the problem, at least in terms of trying to analyze this. We know extrinsic evidence came into them. It came into the court. And now we know this extrinsic evidence is there. But you want to use the actual statements from the jurors themselves as to what role it did or did not play. Now you're getting into the jury and the deliberations, right? The jury process itself is protected. So they might have made those assurances, but I'm not sure that those assurances can be used by either side on appeal, right? The fact that they saw some extrinsic evidence is just a pure factual statement. That it didn't influence them is kind of an opinion statement, and it goes to their deliberations. And so I'm not 100% sure that's a valid thing to note in an appeal, but that it came in isn't valid. Ms. Palin, the former Alaska governor and vice presidential candidate in 2008, sued the New York Times in 2017, accusing it of defaming her in an editorial that linked her political rhetoric with the 2011 mass shooting. The Times corrected the error the morning after the editorial was published. So they feel like they made a mistake. So, fair enough. And, we should applaud people when they're correcting their mistakes. So rather than double down. So I guess we'll give them credit for that. That's good. The case was seen as a test of the landmark 1964 Supreme Court case, New York Times versus Sullivan. So you want to try to go directly after Sullivan, which I suppose you can still do, because the judge's decision was going to be based, as we're going to learn in this article, on the actual malice standard. So the judge said the reasons that he was going to dismiss on the record was his interpretation of the law, which also incidentally was the law the jury was told. So if you're trying to use this as some sort of vehicle to get the U.S. Supreme Court to reconsider New York Times versus Sullivan, which Justice Thomas has shown some appetite for, then, that vehicle is still available. I don't particularly think the rest of the court is particularly interested. There might be one other vote for Thomas's idea, but I don't really see an appetite by the court to revisit New York Times versus Sullivan. At best, maybe you get some additional clarification, but this is a bad vehicle for that kind of a clarification. When I say vehicle, I mean the kind of case that would raise the kind of issues that you want, right? This is a bad vehicle because Sarah Palin is about as public a figure as you can get. She's not the case to revisit the issue. The case to revisit the issue would be someone who is deemed a public figure, but is much more on the margin of being a public figure. So this would be because the idea of a limited purpose public figure has been stretched and broadened. And maybe that's a problem. But Sarah Palin's the wrong vehicle. Her case is the wrong vehicle to raise that issue. You want someone who has a very, very small filing, but nevertheless has some sort of public engagement, and use that as a vehicle to attack New York Times versus Sullivan. So I'm not sure this is a good case to even try to get to where you want to be, because I don't think they're going to just go up and just overturn it based on a case like Palin. It just doesn't make sense to my mind. I don't think there's an appetite for such a big decision at this time. By ruling in favor of Times on Tuesday, the jury affirmed the precedent. Well, the judge was going to do it anyway. And they don't really, that's wrong. Juries don't affirm precedent. That's just bad writing. Bad New York Times. Bad New York Times. The jury has no choice. It's the law. They're instructed on the law. What do you mean they affirm the precedent? What are you talking about? Like they're trying to make a legal decision? What? Finding the newspaper and its former opinion editor, James Burnett, had not acted with the level of malice or recklessness claimed by Palin's team. Public figures must prove news organizations acted with actual malice, and we've discussed this many, many times. Ms. Palin is expected to appeal. The judge said on Wednesday that although neither party objected to his issuing of a ruling while allowing the jury to continue deliberations, he's bringing to the issues of the jurors having notified both parties' attraction in an excess of caution, which, he should do. If any party feels there's any relief they seek based on the above, counsel should properly initiate a joint phone conference with the court to discuss whether any future proceedings would be appropriate, such as potentially a formalized voir dire of the jury. And they didn't respond to immediate comment. So the idea that the judge was considering intervening in this is not particularly surprising. The fact that they were doing so in New York Times versus Sullivan is not surprising. The fact that they were saying there's lack of actual malice, because we know how hard a standard that can be, is not surprising. But it does raise broader concerns, mainly in our present case, but it raises concerns more globally about jurors getting these push notifications, as I get push notifications on my phone as we speak, as you can hear, that might alert you to certain things, right? And then you just see the push notification, and it would necessarily, you have that information. And if that relates to your case, then what do you do? That's a good question, to which I don't have any really good answers. But it is something that, would raises some problems, I think, that are worthy of discussion. All right, so let's talk a little bit about TikTok. TikTok has, unsurprisingly, come out with a revision to their community guidelines and said, in part, or let me see the summary, TikTok updated community guidelines will now ban misgendering, dead naming, misogyny, and content promoting disordered eating and conversion therapy. Okay. So let's discuss this policy and many questions / concerns / issues I have with it, because that's some good rage bait for late in the evening, right? So let's discuss this thing. Let me make this a little bit bigger in my browser. All right. So here's how TikTok phrases it on their page. Adding clarity on the types of hateful ideologies prohibited on our platform. Now, I take note initially of the framing device of hateful ideologies. Okay. This includes dead naming. Question. So, first of all, for those of you who might not know, dead naming is when you refer to a transgender person by their previous name, because many transgender people change their name to reflect their perception of their gender. And dead naming is when you call them by their previous name. So this would be the equivalent of calling Caitlyn Jenner Bruce Jenner, would be dead naming. Now, questions I have. Is that an ideology? Is it an ideology to dead name somebody? Is it any more an ideology to not dead name somebody? Are they both ideologies? They don't seem like either one. It doesn't seem like an ideology. If you want to use someone's new name and not refer to their old name, is that an ideology? If you want to if you want to write something about someone's old name, is that an ideology? I'm not really sure I buy that as an ideology. I'm also not sure I buy it as a hateful ideology, because it's just a statement of fact. This is a fact. It's not even an idea. It's a fact. This was their name. That's just a factual statement. That's not an idea. That's a reality. I mean, it was, in fact, a fact that existed in the past. That was true. And which may not be true now, I guess, maybe, but how is noting a fact, which is just objectively verifiable in every possible sense, an idea? And how is it a hateful idea? I don't quite know. Misgendering, which they don't go to define, incidentally, because, as was pointed out, I believe this was pointed out by, was it Tim Pool who pointed out this issue to the CEO of Twitter on the Joe Rogan show? The right and left have very different ideas about what misgendering is. As Tim Pool said it, according to the left, misgendering is when you don't refer to someone based on their preferred perception of their gender. To the right, it's exactly opposite, right? If you are born male and you say you're female, to the left, refusing to call you female is misgendering. To the right, calling you female is misgendering. It is misgendering you because we don't agree with the concept that you can just define it for yourself. We don't think that makes sense, or at least I don't. I'll speak for myself, at least. And we've discussed this before on my channel. It doesn't quite make sense because, like we did when we did the Dr. Phil segment, for example, and we discussed it, where it's like asking the people, can you define a woman? And they're like, no. So how do you know you're transgender then? If you can't even define your terms, it's confusing. So they don't define misgendering, but presumably it means it from the left-wing spectrum, or misogyny, which I'd like to note does not ban misandry. So hating on men, totally cool. Hating on women, not cool. I don't agree with hating on women, incidentally. I don't think it's good to hate on women. I also don't think it's good to hate on men. I don't think it's good to hate on somebody based on their biological sex. That seems dumb. I don't think it's okay to hate on women. I do take exception to a policy that only bans one of them, because you are providing a protection for one sex and not the other for no rational reason. So that also, as well as content that supports or promotes conversion therapy programs. Again, this gets into the issue of what is a conversion therapy program. When Canada recently tried to define this in their law, and I don't know if they succeeded or not, but I remember reading the proposal, they might have succeeded in defining it this way. I think it might have become law, but I'm not quite sure, and I don't want to speak out of turn. But when Canada was defining this recently, which may or may not have become law, conversion therapy only went one way, right? It became illegal to try to convince someone they're cis. It became illegal to try to convince someone to conform to their birth gender, and so forth and so on. It was only one way, though. It was only one way. It was only a ban on trying to turn someone straight. It was only a ban on trying to make someone more of their birth gender or conform more to their birth gender. It was not the other way around. It was a one-way valve. And I suspect, again, that that's kind of true here. Because what has been happening, for example, in schools with critical race theory and gender theory could be viewed in these terms, but the other way around. But that's okay. It's only the one way. It's only if you try to reaffirm someone's biological gender that it is wrong, according to the Canadian government. And I imagine, although they don't define their terms, that TikTok is of a similar mindset when it comes to such things. So that's a bit of a problem. Though these ideologies have long been prohibited on TikTok, again, is dead naming an ideology? If it is it more ideology one way than the other? Same for misgendering. Is that an ideology? If it is it more one way than another? And conversion therapy programs, is that an ideology? Again, is it more of an ideology one way or another? So if it's an ideology, presumably it's an ideology both ways. That's my point, in case I wasn't making that clear, right? If it's an ideology, it's ideology both ways. Or it's not an ideology. It can't just be like a one-way ideology. That doesn't make sense. Like an ideology can go the other way around. That could be an ideology. So is dead naming an ideology? If it is, it's an ideology both ways around. It's an ideology to say dead naming is good, and it's an ideology to say dead naming is bad. Those would both be ideas, I suppose. So they both are ideologies. But is it really? Because dead naming is a statement of fact. Misgendering, at least to the right, is a statement of fact. Conversion therapy programs, depending on exactly what we're talking about, could be just viewed as responsible therapeutic treatment in at least some manifestations of it. Not all manifestations, obviously, but some. Everything can be abused. It doesn't mean it's all abuse. Those ideologies have long been prohibited. We heard from creators and civil society organizations in support to be explicit. On top of this, we hope our recent feature enabling people to add their pronouns will encourage respectful and inclusive dialogue on our platform. Well, perhaps less so with the inclusive and respectful dialogue. Quite literally, for there to be a dialogue, there have to be two views. Dialogue, dia means two. Dialogue, two logics, two logos, right? You have two views exchanging ideas in a dialogue, as opposed to a one log, right? But how are we supposed to have a dialogue if these views are prohibited? And I suppose the answer is we're not supposed to have a dialogue. And by dialogue, we presumably mean monologue. And we're just going to preach at you. That's what we mean by dialogue, apparently. So that's really weird. All right, so let me see what's going on with chat and so forth and so on. Let's see. Stephanie says she wants a joint stream with Drex. That could be interesting. Bob Johnson asks, how can they define misgendering when they can't define gender at all? That's a very good question. I don't know. Yeah. Boomhurst says Canada spent a lot of time trying conversion therapy on Indian populations by kidnapping kids and putting them in certain facilities. Look, I am not arguing, and I tried to make this point explicit, but I'll make it explicit again. right? I'm not arguing that there aren't some evil versions of what we might call conversion therapy. I am suggesting the possibility that not all of it might necessarily be evil. To say some of it's evil is not to say all of it's evil. So I'm not disagreeing with you that an attempt to kidnap Indian populations and putting them into facilities is wrong. That's wrong. I'm not disputing you. But I'm opening the possibility that some of the, but it's an issue of the label, right? This is a classic problem with label broadening and lack of sufficient nuance in discussion. And I think one of the ways that this has been in an example, for example, is by sexual assault becoming such a wide label for so many different things, not all of which are equally evil. At least in criminal law, we differentiate these concepts. We separate various concepts into various kinds of evil. We talk about them in law in a more nuanced way because they're not quite the same and not all equally evil. And the problem is, at least in part, with a concept like sexual assault, the concept has become so wide in its use that the term becomes a little bit useless. Because the term becomes everything from, stranger's rape in an alley to, he touched my shoulder or something when or something like that. I mean, or the Anara Azari thing, which was a sexual assault, even though from my point of view, he didn't do anything wrong from what he described. And even from what the woman described, it seemed okay. So the problem is that the terms become too inflated and they become useless. So when we're talking about something like conversion therapy, we have to be a little bit more nuanced in what we're talking about so we can have a more intelligent discussion. When words become foggy and muddled, it prevents us from having a discussion about what exactly is good or what exactly is bad. And I'm not suggesting that it is good to take someone who is gay, well, as a child. I mean, I think an adult should be able to consent to pretty much any therapy they want. So I do take exception when it comes to adults. If you are a gay man and for some reason you don't want to be, I think it should be legal for you to have a therapy that tried to change you. I don't know that that's possible, incidentally. It may not be possible, but I think as an adult you should be allowed to do that because you're an adult. What you want may not be possible. That may not be a possible goal to achieve. But if you're an adult and you want to consent to therapy to try to change some fundamental aspect of yourself, I don't see the fundamental problem in an adult making that decision. Now, when we're talking about children, obviously, things get a lot more questionable because we get into the ability of children to consent, which incidentally raises whole kinds of concerns when it comes to transgender stuff, doesn't it? But I think you have to have a more nuanced discussion, and pointing to the worst examples of something is not a good methodology necessarily to say that it's all bad. It's a bit of what would you say? It's a bit of unduly undifferentiated thinking, I think, in some respects. So that's hopefully somewhat clearer about what I was trying to say. Yeah, we call that overloading a variable in computer science. Yeah, correct. I do have a computer science degree, so I do know what you're talking about. But yeah, exactly. You're overloading a term. Exactly. So the term becomes unuseful. Yeah, and it becomes it's like, so are you for conversion therapy? It's like, well, what am I talking about? Am I talking about, dragging a a gay trial to a place where he's going to be beaten and prodded and, you know, all the rest of it. No, obviously I'm not talking about that. So it's like, you know, did Palin win? No, Palin lost, but she has appeal chances. How about the kid drag queens? Well, it raises a whole sense of problems. I think, okay, I have many complex ideas when it comes to kid drag queens for a whole host of reasons. One of the reasons is for very young kids in particular, it is not atypical for them to engage in play that in some sense blends lines, because they're trying to literally play with concepts by playing them out in the world. And I don't think it's necessarily a problem inherently for very young children to want to wear kinds of different clothing, because they have a very undeveloped sense of ego in the very real sense. Like, I mean, they're so young, and so they don't really have much of an ego yet to speak of. They don't have a sense of self. So I think for very, very young children, playing with these concepts can be helpful in some respects. I do take exception to any parent who straight or gay, is taking their child and trying to basically parade them through the child beauty circuit. I'm looking at you, John Benet Ramsey. You know, I don't have to think that, you know, that doesn't seem like a healthy lifestyle, in my humble opinion, for a child. So again, depends a little bit what we're talking about. We have to speak with a little bit more nuance about things. Stephanie says, I have lots of info about a certain one that's very visible, including other family members calling CPS. I'd be happy to cover that, Stephanie. That sounds like something I'm interested in. Yeah, I'm happy with that. Yeah, I'm happy with that. I agree with Cherokee Girl in half with the hormone therapy. You know, I think that that's a real problem for children. I don't think that's free. So I think, you know, what's going on here with this? Sister reported to parents for the wrong thing. All right, so what else can we discuss tonight to keep things a little bit lighter? Let me take a look at our list of topics and see what else we can discuss. Oh yes, we can discuss the sentencing of Kim Potter, who got effectively 16 months in prison. I continue to think, and in large part based on the judge's own words during sentencing, that the charge remains legally non-viable. The judge herself said during sentencing that Kim Potter made a mistake, that no one is arguing that she thought she had a gun, and so forth and so on. It seems to my mind that, and she talks about how it's a split second and needing to act in a split second, and talks about how the person who was shot had a warrant and trying to detain him, and how the use of a taser would have been proper, and so forth and so on. I feel like the judge's own sentencing words reflect realities. I don't think they're untrue, but continue to raise in my mind the question of how exactly we're getting to the requisite mens rea for the manslaughter conviction in this state. So I don't quite see it. I mean, I continue not to see it. I continue to struggle with this as a matter of the way the Minnesota law seems to be written. So I think that I think that 16 months is a good outcome for Kim Potter in terms of the guidelines. The guidelines recommended 7 years. So she got one hell of a departure down from 7 years to 16 months. So that's one hell of a good outcome. And then, what was it? Is it? Yeah. But still, I think the criminal conviction itself doesn't make sense as a matter of law. And I'm not necessarily convinced the Court of Appeals will be able to hear the case within the window. I mean, courts everywhere have been backed up in large parts of COVID and so forth and so on. So it may be the case that she'll win eventually in a somewhat Pyrrhic victory. And the conviction will be overturned after having served her sentence. And perhaps Minnesota has payment for wrongfully convicted people, but I mean, that's the only thing I've got. I agree that 16 months is too long, Bob. I do not understand, based on the trial judge's own observations. I don't understand, based on the trial judge's own words, how the crime meets the statute. And I'm open to the possibility that I'm missing something, and maybe the Court of Appeals someday will explain it to me. But I had a hard time saying, like, how are you saying all these things and concluding that she's guilty at the same time? Because as I'm sure we've talked about, right? Because we talked about judgment notwithstanding the verdict. There is a difference between a verdict and a judgment, right? A jury comes back with a verdict. A judge enters a judgment. A jury can't enter a judgment. They enter a verdict. So when I say, how can you enter a judgment of guilt, I mean that quite literally. Based on what you say are uncontested facts and uncontested findings. I don't quite understand. I mean, yeah, if you win, you get the felony off your record. So you get yourself cleared. You get the disability cleared. So it's like the conviction never happened. So, but I don't quite see that one in terms of it. What else is happening in the news that we want to talk about? Anything going on? Oh, what's mens rea? I'm sorry if I didn't say. Mens rea just means mental state. Mens rea is 2 words. Just means mental state. You have to have the right mental state as opposed to the actus reus. Those are the 2 things you need in a criminal case. You need actus reus, which is the act, and mens rea, which is the mental state. In this case, the mental state required by the relevant law is recklessness. That's the mental state. You have to have a mental state of reckless. So if it's an accident, it's not reckless. And she said it was an accident. She said she didn't know have the gun, so how is it reckless? You know, so that's why I say it's like, how do you get to the mental state required based on this fact pattern? And I don't know. Whatever happened to that female officer who killed a man in his apartment? As memory serves, she got a year. And I think basically half that time. No, she got 5 years. That's right. She got 5 years. Reduced to 2.5. They said they were going to appeal, but they'd be idiots to appeal. Because they can't do any better than they got. So as far as I know, she's serving her 5 years, which can be reduced in half. So 2.5 years in prison for that. I mean, that's a much different fact pattern than this. That's a much different fact pattern than this. They're not comparable in my view. So, and also they're in completely different states with completely different laws, but still. Check out the guy who jumped off something. I don't think I will. We could talk about the Canadian protests. I just don't feel like I have anything valuable to say about the Canadian protests. I don't really think I have anything to add. I feel like I'm just reciting talking points and don't really have any ideas of my own. So I've been hesitant to comment about it just because I don't feel like I have anything that's really my own idea on this. I mean, I agree with everyone who says it's reprehensible, but I just don't feel like I have anything particularly valuable to say. I think that it's truly horrible and truly a sign of a failed democratic country that people's bank accounts are being seized for merely contributing. So let's deal with this. Let's deal with this again in a more nuanced way, all right? Because we can do nuance on this channel, and you guys appreciate nuance, right? So let's deal with this in a more nuanced way, okay? I don't think it's appropriate to just park your big rig and just block a bridge, for example. I don't think that's appropriate. If you want to drive your big rig around and like you're just causing traffic just because of the number of big rigs, like that's one thing, right? You're using it and following all the traffic rules, and you are doing all the things you're supposed to be doing, and there's just so many of you that it has the effect of creating traffic. To my mind, that is a difference than simply parking I'm assuming these things happen. I'm just differentiating in my own mind. That is a difference than parking a truck on a bridge or parking a truck and abandoning it. In my humble opinion, it's different. I believe in the right to protest. I believe in the rule of law. These are things, and I try to apply these consistently. I don't think it's fair to compare this in any sense to BLM, because BLM is much worse with the arsoning and the rioting and the burning and all the rest of it, which is not happening in Canada. But still, to the extent that they are merely just causing traffic, they're just abandoning their trucks, like I can't support that. That, of course, does not change my overall opinion about what the Canadian government is doing. And the fact that they apparently are forcing tow truck drivers, which seems like slavery, to tow trucks and freezing bank accounts for anyone who's merely contributing to try to provide some financial support, and threatening people's pets, and a whole bunch of other dystopian crap. And I think watching the reactions of the news and the left to the BLM riots versus, for example, this has been very illuminating, because you'll hear things like AOC say, like, riots or protests are supposed to be uncomfortable. They're supposed to be disruptive. So the left loves it when it's their team and doesn't love it when it's their team. There's that famous saying, for my friends, anything, for my enemies, the law or the wall, depending on your phraseology. But it's like, yeah, but I try to be consistent in my principles. And I think that, I also think that the idea of Justin Trudeau saying that the people who are supporting the truckers are racists or Nazis is ridiculous. I mean, first of all, they could be a whole bunch of things, right? They could be glowies. They could be counterinsurgents. They could be the enemy. And even if they are, in fact, like truckers in some sense, even if they are authentically of that side, I mean, it's just a law of large numbers thing. When you have enough people, you can just expect that one or two of them are going to be dumb. So even assuming that those are, in fact, authentic people for the trucker side in some sense, I think to say that those people represent the truckers is ridiculous. It's like one Southern Civil War flag and one, maybe a Nazi flag does not, impute the entire movement. That's ridiculous. On its own terms, it's ridiculous. That doesn't make any sense. So I know, it wasn't like it was the leader of the group who did it, who, might have some authority to speak for that group. So it didn't make any sense. $5 from Tia Marie. My wish is that we would allow kids to be kids. Let them be young, innocent, and free. Youth is fleeting. Adults need to quit using them as pawns. Fair. $20 from Barco Verver. Natalie the lawyer chick made a great point that the judge only addressed specific deterrents. She didn't have a problem with the sentence, but supported adding a year for general deterrence to deter other cops from doing bad things. Yeah, so, yeah, I suppose. I'm not sure why. I'm not sure how this would deter cops. I'm not sure what it would deter them from doing exactly. So I'm not sure I even see the general deterrence in this example, but, you know, okay. Yeah, so Trudeau's statements might have been, in some sense, politically expedient, as someone in chat pointed out, to justify the emergency. But it doesn't make any logical sense, and I try to be logically consistent. So it doesn't make any sense. Yeah. Yeah, 20 live streamers nonstop, haven't seen anything really bad. Right. I think that's the overall sentiment, right? The overall sentiment from these many live streamers is there's nothing really bad going on. So that seems to be the representative experience. So even if these other experiences are correct in some sense, the representative experience doesn't reflect that. And so you should try to judge it based on, what seems representative to the group. To some degree, that seems to me. What else is going on that we can talk about? There's this story about this Judge Bruce Murrow, this Wayne County judge, who got a 6-month suspension for apparently sexually taunting female prosecutors. But I read the story, and I'm not 100% sure what's going on in that story. But Stephanie sent me another article which we could review live to see if it provides any more detail about what's going on, because the one story I read didn't seem that bad, or I was missing something. So let's see if this case, let me fix the margins on this, because when I change from thing to thing, I have to change the margins so it looks right in OBS. All right, let's take a look at this. On April 3rd, 2019, the court hearing looked and sounded most like any other. Maricopa County Superior Court Judge Aaron Baron Otis is about to sentence a man who's pled guilty to 4th, 5th, and 6th felony. But about 8 minutes into the proceedings, as Otis is shuffling through papers, he makes a quiet, offhanded comment. "I can hear those bubbles." The defendant and attorneys presented in their courtroom then chuckle. What the courtroom cameras and the minute entry don't show is that Otis and her staff threw a party in the courtroom for a defendant's young son, whose birthday happened to fall on the sentencing date. Which, I don't know if that's necessarily appropriate, but I don't know if it's necessarily inappropriate either. There were bubbles, treats, and singing. During the sentencing, the top of the boy's head can be seen moving in the gallery and shooting a light-up bubble gun. Well, that's not super appropriate for a courtroom. A half-filled bottle of pink bubble solution can also be seen on the stand where witnesses testify. That seems odd. Judge Otis and certain members of her staff have allegedly engaged in years of inappropriate conduct and contact with defendants, including routine ex-parte communications, which, ex-parte communications are problematic at best, according to judicial communications. Otis and her staff also routinely mock and ridicule people during hearings and trials by routinely emailing each other cruel and obscene statements, jokes, and memes. Legal and ethical efforts say the overall culture in the courtroom was astonishing and horrific when she presided over death penalty cases. Well, that does raise a little bit of concern there. Otis is on the bench, is now a prosecutor. She resigned from the bench in the middle of a 2-year investigation. Okay, well, that sounds problematic. Confidential warning letter in the case she should ever return to the bench. The commission's private letter states she improperly allowed her staff to exchange memes and emails, but not find clear and convincing evidence related to any other investigation. So, ex-party communications happen daily, routinely, almost every single day. I think people didn't just believe the inmates is going on. Yeah, that sounds like a problem. Ex-party communications are very, very rarely authorized and for very limited purposes. And if they're happening every single day, something has gone wrong. She added, I think they're like, what judge is going to come into a locked courtroom and talk with inmates on a chain? And it happened almost every single day. You don't get to have this little side conversation with someone else because bad things happen. It's often a sign you're either favoring them, or now you're buddy and you want to help them in a way you don't help other side. Or I want to threaten them, intimidate, extract favors that I don't want the other side to know about. It's in tension with the role of the judge, you think? ABC 15 obtained a 5-page affidavit written in April 2020 by defendant Victor Hernandez, who was convicted of first-degree murder. The affidavit outlines multiple times when Otis spoke to him without his attorney's presence, sometimes about his rap music. Schaefer said specific parts of the statement sound true. Somehow Otis got a CD of his rap music of that particular defendant. She talked about how much she liked the music and would listen to it. And this day, I don't know how she got that CD. Maybe he has a really good promoter. Really good promoter. Man. Before leaving the bench, Otis had been negotiating and talking about terms for a job as a high-level county prosecutor for months leading up to her hire. She was still rolling on motions and sentencing a defendant in at least one capital criminal case. While she's interviewing for a prosecutor position, I don't know. And there's a lengthy statement here about whatever, but you know. So perhaps some misgoings on in this courtroom, it seems. Yeah, so it's a non-issue? I believe that. I believe it's really a non-issue. Most of the memes are probably not. She was even got talking about which defendant she had crushes on. Ooh, a little love connection in the courtroom there. I don't know, man. I could sentence you. I could convict you. But you've already taken my heart. That sounded better in my head. I need to work on that. All right, what else can we talk about? Stephanie, we can talk about anything you like. What do you want to talk about, Stephanie? Hey, Stephanie, as I'm sure many of you know, has been developing her own YouTube channel and has been working on stuff for her channel for quite some time. And I just want to give her encouragement. I told her this privately, and I'll tell you publicly. One of the things she's told me about, and it's the same problem. It's a problem I had about not liking my early work on my own channel. And you know, as creators, we all have our various problems, but this is a problem I went through, and so I want to offer it to you just as in case you're ever interested in this, and maybe it will speak to some of you out there, right? When I first started this channel, I don't even know, like 4 years ago or so. These numbers are a little off. I started this channel maybe 4 years ago, but I didn't get really serious about this channel until 2.5 years ago. And you might want to know, like, what was happening for the other 1.5 years. Basically, me hating everything I did was the answer to that question. And trying to produce videos occasionally and hating it. And it took some time to try to find, I suppose, what you might call my artistic voice. And so I just wanted to say this to Stephanie and to everyone else, that if this is a problem for you, my only advice I can really offer here is that you have to go through it. I don't know of another alternative. You just make stuff, and eventually the stuff is good and it works, and I don't know what else to do. But I've seen the stuff Stephanie's already produced and is already on her channel, and I think she should be proud of it. She is very knowledgeable in firearms. She's very knowledgeable in the subject she talks about. She can, take apart a Desert Eagle, I'm sure blindfolded, without even really thinking about it. And she talks about stuff intelligently. So it's something that you should talk about. Stephanie, why don't you drop a link to your channel? You're a mod. You have the rights to put a link to your channel. Why don't you drop a link to your channel and I'll pin it so people can check out your content. And she's told me about some of the content she's posting in the future, and it excites me. But I will leave that to later. And STFU FFS says quite properly, you still irrationally bathe in self-hate at times. Right. So this problem has not gone away. It's just gotten better. So it hasn't gone away. But yeah, you're absolutely right, STFU FFS. I still bathe in self-hate sometimes, irrationally. And still hate my work sometimes, and still hate things, and get overly self-critical and depressed about my stuff and beat myself up and stuff. Yeah, it's a problem. Or it can be a problem for some creators. So, but thank you for sharing that. Yeah, my only advice, yeah, you are your own worst critic many times. Is very true. And there's the link for Stephanie's channel. There's the link for Stephanie's channel. So we'll pin her comment. And you should check out her comment. You should check out her stuff and see if it's for you. You might like that kind of material. Again, give it a shot. She is field stripping at Smith & Wesson M&P. Should we watch field stripping the Smith & Wesson M&P, or should we watch field stripping and cleaning the Sig Sauer P220 ACP? Those are both good videos. I think we should watch field stripping the Smith & Wesson M&P 5045 ACP together. I think we should watch this video, and we should learn how to field strip the Smith & Wesson M&P, which is a very good gun, incidentally. It is definitely on the list of recommendations. Other ones that I tended to recommend for people when they were getting new into it, Springfield Arms was very popular, or I thought was a very good choice. Glock obviously is a good choice, although Stephanie hates Glock. So, she thinks it's a piece of Tupperware, a piece of plastic. So we have a little mutual ribbing about that topic. Sig Sauer obviously makes some good stuff. What else is really good? But those are the ones that I typically thought of as really good recommendations. Let's put on the earphones and let's watch a video from Stephanie and give Stephanie some support. She needs a little bit of affirmation that she is doing perfectly fine for someone who is creating, and it can be a little bit challenging sometimes. I want my answer about Jason first. Well, who's Jason? Stephanie says no. Okay, well, if Stephanie says no, I won't do it. I mean, I'm not gonna do something Stephanie doesn't want to do. Do I have a caliber preference? I think I don't have a strong caliber preference, to be honest. I think there's many different ways to go about this. I think that, of course, the 22 that you have is better than a 45 in the safe. So there's that. It depends so much on your application, and depends so much on, the concerns you're trying to balance against each other. But, I think I shoot 9mm for whatever it's worth. So, I mean, there's my answer. I shoot 9mm. So I don't know if that's helpful. One of the nice things about ammunition in the PPQ, that's a great gun. Great trigger on the PPQ, boom her. Great choice. Yeah, the Walther PPQ, fantastic trigger on that gun. Which is definitely not true for the Glock, incidentally. $10 from Life of Brian, who said, what can we do when the entire legal profession is corrupted? Nothing is not a valid answer, because the corruption of judges is making U.S. perilously close to Canada. I don't agree with your premise, so I'm not going to answer the question. But the nice thing about ammunition in the last 15 years is that it's developed so nicely. So, like, even with smaller calibers, the ammo has developed so nicely that you don't trade off as much as you used to. So, like a 380, I mean, all things being considered, obviously, you know, but a 380 with some of their cartridge choices can be a perfectly fine, suitable choice. Especially if you want something really light and really, you know, portable. I mean, you know, would you like to be shot with a 380? Probably not. Are you going to do a review of the Durham report? I don't know what that is. The Smith & Wesson MMP Shield? Yeah, good choice. Absolutely. The Jefferson Davis. I don't know who Jason Davis is, Stephanie, or I'd be happy to answer for you. Who is... Let me see. Okay, Jason Davis comes. I'm looking for the comment. Okay, here it is. Jason Davis, what's your take on Oklahoma's new law that makes it illegal to film cops and post to the internet? By this law, the George Floyd video would have been punishable by arrest. I think the law is illegal, and I can't believe that they passed it, to be honest. It's a little bit more nuanced in the law than that, but the way the law is written can lead to those kinds of concerns. But I think that Oklahoma is flying face in the smack dab in the face of case law. So I think that their law is quite possibly unconstitutional. STFU FFU says, I love the Springfield 45 XDS and XD9. That's a great gun. The 9XD, that's a great gun. But my first love is the gun that destroyed Remington. The Remington, yeah. Walther Model 432. That's cool. Yeah. Why don't you super chat with what you think is the best caliber? And we'll add it up based on dollar values. So you can vote for what you think is the best caliber with dollar values. SIG P365, good choice. MP9 Shield, good choice. Is anyone here a big fan of Springfield Arms? I think they make some good stuff. Desert Eagle's a bit impractical. H&K. I'm not very familiar with H&K, Heckler and Koch. I mean, I know they have a good reputation, but I've never really shot their stuff, so I don't really have a strong opinion about Heckler and Koch. But yeah, they make good stuff. So I hear. It's very expensive though, all things considered, but H&K makes a superb 45. Yeah, I thought for 45 I'd go with who was it? Kimber. I've never shot one myself, but I always thought they had some really nice looking stuff. 7mm Rem Mag, 1.5 miles effective range, I suppose. $20 from Stephen Cooper. 44 mag with 45 ACP in second, which I find funny about my opinions because my favorite are my CZ75. Okay. 44 mag with 45 as a secondary. I mean, that's a lot of gun. That's a lot of gun. Taurus 44 Magnum Snub Nose. I mean, I would think that'd be pretty brutal to just shoot. 44 Magnum coming out of a snub nose. I think that'd be a bit difficult, but okay. Stephanie says Kimber Customs aren't worth the price. Fair enough. Rock Island Armory. .12 gauges. Shotguns are good. Taurus Judge. That Taurus Judge revolver, that's a cool one. And then there was that revolver, was it called the Rhino? That fired out of the bottom cylinder instead of the top. I don't know how good that was to try to deal with some recoil issues. That was a cool looking gun. I never fired it though, but that looked badass. But the Judge is pretty cool because it's chambered in, you can fire, 44 and 310 shotgun shells out of it. That's pretty badass. You have a Judge? That's cool. That's cool, Stephanie. Judge has no range. Chipica Rhino. I know a lot of people that like the Rhinos. Yeah. Yeah, that was a good one. But yeah, I think these are some good choices. The SIG 365 and the 900 series one, which I can't quite remember, are both good choices. Glock is a good choice, and they have single stack ones too, of course. Springfield Arms, M&P. Yeah, some of these are some real good choices for some stuff. 22 long rifle revolver with 16-inch barrel. That's pretty cool. I mean, a 22 that you have on your person is infinitely more valuable than a 45 in your safe. So when you're thinking about it, you got to think about something that you're actually going to use, practice, have some familiarity with. You got to think about your applications. You got to think it through. And, if you wind up even with like a 32 or 25 or something, or 22, I mean, I'd rather you have that than nothing at all. Yeah, I think the SIG 365 is slightly overblown. I don't think it's quite the second coming, but it's a very, very fine firearm. So it's definitely a good choice for shooting. Although that Walther PPQ, that's a badass firearm. That trigger on that PPQ is really, really nice on the Walther. As a home gun, that Walther is a really good choice. I love the trigger on that Walther. PPK. Yeah. Lee Bear for customs, sure. AR and 458 SOCOM. It's a little bit much. It's a little bit much, man. All right, well, I'm going to head off for now, guys. So you can go over to Stephanie's channel. It's in the comments. Check out her stuff. Make sure to subscribe so you can get some notifications. Hit the bell on her channel. Do all those YouTube things. Give her some support. She's been a big supporter of this channel. She's helped me a lot in terms of story selection in particular. And so, go to her channel and show her some love. Do it right now. Click the link right now. Click the subscribe button. Do it. check it out. You know, all those good things, man. And we wish her a lot of success in the start of this journey. And it can be frustrating at times, but it can be rewarding. I'm going to sign off for now. Hope all's well. Cheers and good night. Oh, there were a couple other super chats I'm not sure I read. Legend 1, Taurus 44 Magnum Stumbers. I read that. Rock Island Armory, 1911. And STFU said, I forgot my 45 Long Colt Henry brass body lever. That seems highly impractical.